Morning. It's the appointed time. We have a quorum. I call to order the meeting of the Bills Committee. Let's invite representatives of the administration to come inside the conference room. The administration has given a response to issues raised at the meeting on 27th of February 2025. The paper number is LC paper number, the LC paper number is LC paper number CB brackets 1385/2025 brackets 02. The list of follow-up actions arising from discussion at the last meeting is LC paper number CB brackets 1385/2025 brackets 01. The administration has also given a response to the submissions from deputations or individuals and the views expressed by deputations and individuals at the meeting on 14th of February 2025. The paper number is LC paper number CB brackets 1385/2025 brackets 03. I will first ask representatives of the administration to brief members on the two papers, the two responses. Members who wish to speak, please press the request to speak button. Welcome, Permanent Secretary and the team. Well, who is going to brief members on the responses? Ms. Doris Ho, the Permanent Secretary. Thank you, Chair. I would like to first brief members on the response to issues raised at the last meeting. Some members asked when and one-off event is held in the Victoria Harbour, some temporary floating pontoons may need to be installed for participants of the event to easily embark and disembark from vessels. Members wanted to know whether these temporary floating pontoons would be approved and what the approval process is. We have consulted the Marine Department. The Marine Department officers informed us that these would require approval from the Marine Department and a permit would have to be issued for these floating structures. After the relevant permit is issued, it would require the ship surveyor's inspection before the floating structures can be used. The effective period for the permit would be at its longest 26 weeks. Members also asked about some provisions at the last meeting. For the proposed section 3 fee sounded confusing. We were urged to review the provision. We have also referred to the contents of the proposed section 3 fee. What is going to happen for non-permanent reclamation? For the exemption granted by the Financial Secretary, if it has been suspended, how are we going to calculate the permitted construction period? Members, please refer to the slide shown right now. Let's refer to the two red boxes. The contents say that for non-permanent reclamation, the longest period granted by the Financial Secretary would be 7 years. If necessary, the Financial Secretary may extend that period by 1 year. So these essentially speak out the contents of the two red boxes. If there is no suspension, the permitted construction period would be 7 years, and the financial secretary may extend the period by a year. Now, with member scenario, you may refer to the contents of the blue box. Should there be suspension, how will the permitted construction period be calculated? This example assumes that in the 3rd year, there is a suspension for a period of 1 year. How we're going to calculate the permitted construction period after that is as follows. In the proposed new section 3 fee 2, we will calculate the period in the sense that we would add after 7 years the period equivalent to the period of suspension. So here you can see after 7 years we would add another year because there was suspension of a period of 1 year in the 3rd year. So that would mean for there being an 8th year. So in accordance with the proposed new section 3 fee, if the financial secretary has to consider a potential extension of the project, in accordance with the proposed new section 3 fee 3, we will not consider the extended 1 year. So in the end, the permitted construction period would still amount to 7 years. So in accordance with the proposed new section 3v3, the permitted construction period would be regarded as 7 years still. So the financial secretary can still extend for another year. So that year, the year to be extended would be the 9th year. I hope this example can illustrate what happens when there is suspension of the project, how we are going to calculate the permitted construction period. I think at the last meeting we did read together section 3 fee 2 and 3 fee 3. They are, after all, in the same section. It may be confusing to members what the provisions refer to because they actually refer to different scenarios. We have reviewed the drafting to see if we can make things clearer, and we believe that we can. So in the proposed CSAs, we do address this issue. We have incorporated members' feedback raised at the last meeting to make clear for the different subsections. They refer to different scenarios and how the permitted construction period is to be calculated. We can elaborate on this when we talk about the proposed CSAs. This is the first paper, first response that we would like to brief members on. As for the other response, that is the response to the submissions from deputations and individuals, as well as the views expressed by deputations and individuals at the public hearing. We have received submissions and views expressed by deputations and individuals at the public hearing. We believe in general deputations and individuals supported our proposals. I would in particular like to draw members' attention to paragraph 3 and paragraph 4. Upon implementation of the bill, we actually have plans to make use of streamlined procedures to deal with certain applications. And we have provided examples to members for members' reference. Say, for the new Praya at Kennedy Town, we want to construct a boardwalk. There, for paragraphs 5 to 7, we emphasized that even with the passing of the bill, it would not undermine the role of the court in the process. It is because whether to undergo reclamation, there is still the overriding public test to be met, and this is an executive process. The bill does not change that. In future, if members of the public are aggrieved by the decision of the chief executive in council, they may still lodge judicial reviews. The bill's provisions do not change the roles of the executive and the judiciary in the process. For paragraphs 8 to 11, let me say this. For the amendment bill, the aim is twofold. One, for large-scale reclamation in the Victoria Harbour, we will have a more formalized mechanism. It still allows public participation. After receiving public submissions, upon analysis of the government, the materials will still be sent to the Executive Council for consideration. For harbour enhancement works, both in form and function, we want to relax certain restrictions. We hope to also implement a streamlined process for non-permanent reclamation. It is because these works will not cause irreversible damage to the Victoria Harbour. With the streamlined process, it should enhance public enjoyment of the harbour and take forward the necessary works as soon as possible. Paragraphs 12 to 17. Whether it's the formal mechanism for large-scale reclamation or for the streamlined process for harbour enhancement works and non-permanent reclamation, there is public participation. We would have 2 months for receiving public submissions. The streamlined process would also incorporate members' feedback. Apart from consulting the district councils and the Harbourfront Commission, we will also upload the proposals Development Bureau's website, as well as consult the Legislative Council to consult members of the council as well as members of the public to have the Executive Council consider the relevant views. That's it from me. Thank you. Dr. Lo Wai Kwok. I'll assign a 4-minute time limit. Thank you, Chair. In relation to what Ms. Doris Ho said, in relation to the calculation of the permitted construction period, it will just be duly extended the period if there is suspension. I do support this because this is reasonable, but can the permanent secretary give examples on why the exemption may be suspended? If there is suspension in the period causing a delay in the works, it is not ideal. So can the permanent secretary provide examples on why the exemption may be suspended. Maybe there is a judicial review and some more time is needed for consideration. All right, Permanent Secretary. Why there is suspension is because when the Financial Secretary grants an exemption, some conditions may be imposed. If the contractor has not complied with the conditions and the situation is quite serious, we may revoke the exemption temporarily, but we don't think it will happen often because the relevant departments should ensure the contractors comply with the conditions, but we need to accommodate the possibility, remote as it may be.
Dr. Low, well, I said a moment ago maybe there was a judicial review somewhere along the line, and therefore you have to suspend the approval. Is it a likelihood? Permanent Secretary. Thanks very much, Dr. Low, for the follow-up. We do not rule out this likelihood. Well, the way it is designed, if judicial review were to take place, a suspension of the approval, this can take care of this. Right, any further comments on the two papers? If not, since the last meeting on the 27th of February, we have been continuing with the clause-by-clause scrutiny of the bill, and we were up to 3P, and that is 2656 on the blue bill. And for the backed up copy, it is CP1 1758, bracket 02, page 0024. So we'll be continuing with 3Q. Will the legal advisor please also have a look at the English version? Yes, Madam Lee, please. Chairman. 3Q is about the non-permanent reclamation, and there is a need to give a notice, and 3Q is about a progress report of Harbour non-permanent reclamation. There is a time limit imposed on this, and there is a need for a progress report to make sure that work will be completed within the specified period. 3Q1 refers to this section applies if there is a progress report, and 2, the specified officer must submit a report to the FS on 2 dates, A, on each anniversary of the intended starting date. Let's say the project commences on the 1st of January, then every 1st of January a report will have to be submitted, and also on a date no later than 3 months after the completion. 3, the report must A, be made in the form specified by the SDEV, and B, it must set out the progress of the non-permanent reclamation up to, in the case of the anniversary report, then a date not earlier than 3 months before the anniversary. Now let's say the commencement date is the 1st of January, anniversary date is the 1st of January. Then it should cover up to the 1st of October. Mr. Lee Chen-keung. Chairman, Item 4 also refers to the report. Does the report have to refer to a third-party supervision, like the seabed recovery and also the reinstatement of the breakwater in the vicinity? Does it require any inclusion of any photos for comparison in the progress report? Madam Lee. Chairman, thank you. Thanks very much for the question. Now, bracket 4, the FS may require the specified officer by written notice to provide additional information that is necessary to monitor the progress of the reclamation. Now, the whole purpose of the non-permanent reclamation is to ultimately restore the seabed. So this has to be undertaken in the course of the project. This forms part of the report. Mr. Lee, I'd like to seek confirmation that is this report to be submitted by the Works Division or is it going to be submitted by a third party? If it is submitted by the Works party, it would be a good idea. But how are you going to be monitoring the situation, or will the government play a monitoring role in the submission of the progress report? Madam Lee. Chairman, it is the specified officer who submits the report, a government official. Basically, that let's say it is a foreshore and seabed construction work, it would probably be the director of lands or the specified officer. It is a government official. And for the progress report, it is the contractor that will be submitted to the director of land. It would be for the government to make sure that the report is reasonable, and the specified officer may seek opinions from other departments. The government has a monitoring role there. Will Madam Lee please clarify one point about the reinstatement work? Is it included in the exemption period? Yes, it is included. Right, if it is included, we said a few moments ago that the work may be suspended because of certain issues, like the issues referred to by Dr. Low. Now, if the work remains unfinished, then the government will have to carry out the reinstatement work. So how would you handle this kind of a scenario? And how do you deal with the duration? Let's say, for instance, it is an undesirable situation if they've already undertaken part of the work and there is a protracted delay, and maybe they're still dragging on the matter after the 9th year, and this is supposed to be a non-permanent reclamation, but they may be dragging on the matter for a long, long time. How you deal with this kind of scenario? Madam Lee? Or Ms. Ho? Chairman, specifically referring to your scenario, the non-permanent reclamation falls by the wayside, and there is no way the project will continue. I think we have to carry on with the non-permanent reclamation. The contractor may not be able to carry on, but the works department will have to identify an alternative contractor. It may take a bit of time, however hard they try, and the works department will have to assess the situation. The FS has approved a specific period of time, and if the replacement contractor fails to complete the work within the specified period of time, then there may be a need for application to be made with the FS for an extension, maybe by 1 year. If 1 year is not quite sufficient, then we have to make a report to the FS, and depending on the circumstances, handle the matter accordingly. As we said, if there are problems with a contractor, it doesn't mean to say that we have to leave the project aside. So if 7 + 1 years are not enough to deal with the project, then we'll have to submit a request to the Financial Secretary for additional extension. Mr. Lee Chen-keung, Chairman. I agree with your scenario that if the project falls by the wayside, we have to identify an alternative contractor, and there is a need for flexibility. But if contractor A were to fold up or fails to carry on because of litigation, and contractor B would have to take over, then contractor B will need to apply for the permit. And I don't think it can replace the former contractor during the specified period. What do they have to make an application? Maybe they will add certain new elements. Mr. Lee, if company B were to take over, it has to assess whether company A has undertaken a certain scope of work, and that would take quite a bit of time. And during this period, things are not happening. Nothing is happening. So if this scenario were to crop up, what flexibility would you be giving to company B? Ms. Ho. Right, regarding the application to the Financial Secretary, it is the job of a specified officer, and it is in relation to this non-permanent reclamation that they would submit an application to the FS. It's not really the contractor that will be doing the application. Now, the application is in relation to that particular project. Now, somewhere along the line, there may be a need to replace the contractor, but it doesn't in any way affect the exemption granted by the FS. So we do not see the need or desirability to start the application afresh should a contractor be replaced. In answer to Mr. Lee's earlier question, now he was asking by the time the non-permanent reclamation is completed and reinstatement work has to be undertaken to the seabed, who will be monitoring the situation. I think in our internal guidelines, when the SO is submitting a report, we have to remind the contractor to carry out the reinstatement work according to the procedures. And up above them, there is a department that is supervising them, and under the EIA report, they have to carry out the reinstatement work. So the Works Department will have to supervise all of that. By the time the report is presented to the FS, the Development Bureau will also play the gatekeeping role to ascertain whether the reinstatement work has been completed as per the original requirements. So there will be different layers of supervision. In our internal guidelines, we will spell this out in no uncertain terms.
Yes, Ms. Leonie Lee, please proceed with the clause-by-clause examination. Thank you. We were talking about how the report would have to set out the progress of the Harbour non-permanent reclamation up to 1 in the case of subsection 2A. If the intended starting date is 1st of January, it would be not earlier than 1st of October before that year. 1st of January. 2 in the case of subsection 2B, the completion date. Subsection 4. The financial secretary may by written notice require the specified officer to provide additional information to enable the FS to monitor the progress of the reclamation. Please continue. Thank you. Section 3R. Well, actually, for sections 3R, 3S, and 3T, they are all related to extension of the permitted construction period. Section 3R, subsection 1, a specified officer may apply to the financial secretary for extending the permitted construction period of the exemption. Subsection 2, an extension application may be made at certain points in time, A, no earlier than the date on which the Harbour non-permanent reclamation starts to be carried out, and B, no later than 6 months before the date following the end of the permitted construction period of the NPR exemption. Let me give an example. The intended starting date is 1st of January and the completion date is 31st of December, and the next day would of course be 1st of January. So if we count 6 months before that, that would be 1st of July. So if one wants to apply for extension, one must apply no later than 1st of July. Mr. Andrew Lam, 4 minutes. Thank you, Chair. For extension applications, setting dates, I have no problem with that. But why did you set the period to be 6 months? Different projects have different scales. Some take only 1 year to complete. Some would take 7 years to complete. And as you may know, often project teams would be rushing their work in the last 6 months if they cannot apply for extension in time, or there are some unforeseen circumstances in the last 6 months. What is going to happen? Would the project team have to apply to the financial secretary an entirely new exemption? So I have 2 questions essentially. 1, why 6 months? 2, if one cannot make an extension application before the 6 months, what is going to happen? Thank you. Ms. Leonie Lee. Thank you, Chair. We set the period to be 6 months because we communicated with different departments. They think 6 months would be a good period for one to know in advance that they may need an extension. So we are basically encouraging them to apply as early as possible for an extension. As for what Mr. Andrew Lam said, should there be unforeseen circumstances, whether one can make an extension application later than 6 months, they may raise that application, but the financial secretary would consider this to consider whether the application is reasonable, and would that delay the works beyond the 8-year period. I have a brief follow-up, Chair. Let me give an example. One has chosen not to apply for an extension, but then say if there are, say, variation orders, they may still complete the works, but they cannot carry out the reinstatement works in time. what is going to happen. So the works are not unfinished, but there's still waste in the area. How would you deal with the circumstance or this case? Let me answer this question. In our experience dealing with works projects, we have actually spelled out in law for reclamation projects. Works departments would have to submit annual progress reports. The purpose of submitting progress reports is for us to identify early on potential circumstances that may delay the works and in turn needing an extension. So I believe the works departments would closely monitor the situation, the progress of the contractor. With deadlines set, works departments would make sure they are vigilant in making sure that the contractors would meet the relevant deadlines. If they fail to meet the extension application deadline, well, we don't think that is likely, but should that happen, say, like Mr. Andrew Lam said, the project team cannot carry out the reinstatement works in time, we would ask the relevant team to submit an extension application for the financial secretary's consideration. So the financial secretary may ask them to apply for an exemption anew, or the financial secretary may allow for the reinstatement works to be carried out still. Mr. Andrew Lam, I think the permanent secretary's answers are quite clear. So the team may still make an extension application. Whether the financial secretary grants it is another story. I mean, there are multiple factors that may cause a project to be incomplete. And of course, if they can't complete it in time, the public may challenge this. So I think allowing an application to be made anyway, that would be reasonable. An extension application has to be submitted 6 months beforehand, and if there are unforeseen circumstances, an extension application may still be made. It would be dependent on the financial secretary to see whether to grant the extension application. I think Mr. Andrew Lam was just trying to clarify the situation. Thank you. Ms. Leonie Lee, please proceed with the clause-by-clause examination. Thank you. We're now at subsection 3. An extension application must specify A, the proposed period of extension of the permitted construction period and the justifications for the extension. When the financial secretary considers the application to see if it is reasonable, if the financial secretary thinks that there is inadequate information in accordance with subsection 4, the financial secretary may require the specified officer to provide additional information for justifications. Subsection 5. If a requirement made under subsection 4 is not complied with, the financial secretary may reject the extension application by a notice published in the manner set out in section 3J5. Subsection 6. A notice under subsection 5 must state that the extension application is rejected on the ground that a requirement made under subsection 4 is not complied with. Mr. Lee Chun-Kung, Chair. I think what Mr. Andrew Lam proposed is quite valid, and I would urge the administration to review the application of the scenario. So for specified officers, the applications would be made by them. They are government officials. So contractors would have to go through the Works Department, say the Lands Department, to make an extension application. And if there is a dispute between the Works Department and the contractor, and a report or the relevant information is not provided by the contractor, what is going to happen? Is there any way for the contractor to lodge an appeal, or can they go past someone else instead, or go directly to the financial secretary to make the extension application? I think often there are conditions in agreements between works departments and contractors on disputes. Perhaps Ms. Doris Ho can address this question. Thank you. Mr. Lee Chun-kang raised another question on the 6 months period as well. I think when we get to Section 3Y, we can have Ms. Leonie Lee brief members in detail subsection 3 of that section. That would address the concern of the member for the proposed scenario. If one misses the 6-month deadline, one did not make an extension application to the financial secretary in time, what is going to happen? In section 3Y, subsection 3, we will deal with this scenario. Basically, the financial secretary may give directions. A direction to reinstate the harbor, for example, or any other directions that the financial secretary considers appropriate. So Ms. Leonie Lee can elaborate on this when we get to that section. As for the other question of the member, I would say this. Should there be disputes between works departments and contractors, it would be dealt with the contractual clauses, just like in general for works agreements. Thank you. Ms. Leonie Lee, please proceed with the clause-by-clause examination. Thank you. We are now at Section 3S, Extension of Permitted Construction Period Decision. Subsection 1. The financial secretary may, on an application made under Section 3R1, decide whether to grant an extension or refuse to grant it. The financial secretary may not grant an extension under subsection 1 unless the financial secretary is satisfied that A. It is reasonable to grant the extension, and B. The aggregate duration of the following in respect of the NPR exemption does not exceed 8 years. The following being 1. The permitted construction period, that is the period first approved by the financial secretary, and 2. The extension, so it cannot exceed 6 years. So we will elaborate on this in subsection 5. Basically, the period cannot exceed 8 years. Subsection 3. As soon as practicable after a decision is made under subsection 1, the financial secretary must publish a notice. Subsection 4. A notice under subsection 3. A must state the financial secretary's decision, and B must 1. If the financial secretary grants the extension, specify the period of the extension, or 2. If the financial secretary refuses to grant an extension, state the reasons for the decision. So that is section 3S. Excuse me, there is one more subsection. So as I said earlier, for subsection 5, a permitted construction period may be extended under this section more than once. Next, section 3T. Extension of permitted construction period under exceptional circumstances. Like I said earlier, we talked about extension in 3S as well, but this is a different scenario. Subsection 1, the financial secretary may, on his or her own initiative, grant an extension of a permitted construction period that the financial secretary considers appropriate. Subsection 2, the financial secretary may consider exceptional circumstances exist before granting the extension.
Bracket 3. If there is an extension of the work period, he should publish a notice. And bracket 4, the notice under subsection 3 must state that an extension is granted. B, it must state the reasons for granting the extension. And C, it must specify the period of the extension. And bracket 5, if the construction period is extended by the financial secretary, then the length of that permitted construction period does not include the period of time so extended, i.e. 8 years. In some cases, in the course of work, there may be some problems and work has to cease. Let's say some relics are unearthed, then work will have to be suspended, and the financial secretary can also grant an extension for this kind of scenario. Please carry on. 0029. The extension in these special or exceptional circumstances can be more than once. Division 4, supplementary provisions. We talked about the revocation, suspension, and expiry. These divisions all about these. 3U is about non-compliance with conditions imposed in respect of HER exemption or NPR exemption, or with Section 3Q. Bracket 1, if the FS is satisfied that there is a failure to comply with the following, then the exemption may be suspended or revoked. Now, these conditions are 1A, a condition imposed under Section 3L5 in respect of Harbour Enhancement Reclamation exemption. B, a condition imposed under 305 in respect of non-permanent reclamation exemption. And C, a requirement for harbour non-permanent reclamation in respect of which exemption is granted. If there is a non-compliance in this area, the FS may suspend or revoke the exemptions. And we will be giving members the details in 3Y. 3U2 now. If the FS decides to suspend or revoke the exemptions, then a notice must be published. Bracket 3, the notice must state the FS's decision and the reasons for the decision. Bracket 4, a decision made under subsection 1 takes effect on A, the date on which a notice is first published in the Gazette, or B, if a later date is specified in the notice, then the later date. Well, let's go on to page 0030, bracket 05. After an exemption is suspended, the FS may lift the suspension if non-compliance has been rectified. Now bracket 6, if the FS decides to lift a suspension, then the FS must publish a notice under 3J5. Bracket 7, a notice must state the FS's decision and reasons for the decision. And bracket 8, a decision made under subsection 5 takes effect on A, the date on which a notice is first published in the Gazette, or B, if a later date is specified, then the later date. Please carry on. Now we move on to 3V, the effect of suspension. If an exemption is suspended, then the exemption ceases to be in force during the suspension period. Bracket 2, if a suspension of an exemption is lifted, the permitted construction period continues to run as if it had been extended by a period of time that is of the same length as the suspension period. We will be moving a CSA there to make it easier to comprehend. We move on to page 0031 now, and bracket 3. Despite the extension, the length of that permitted construction period does not include the period of time so extended under section 3S2B. And bracket 4 is about the suspension period. Basically, it means the period during which the exemption is suspended. We move on to 3W, non-compliance with section 3P. (3P) is about the non-permanent reclamation, the commencement notice. It's only in this kind of reclamation that there is a specified period. If there is a failure, bracket 1, if the FS is satisfied that there is a failure to comply with the requirement, then he or she may revoke the NPR exemption. So there is no suspension, there is only revocation. Bracket 2, if the FS decides to revoke an NPR exemption, then a notice will have to be published. Bracket 3, the notice has to specify the FS's decision and also the reasons for the decision. Bracket 4, a decision made under subsection 1 takes effect on A, the date on which a notice is first published in the Gazette, or if a later date is specified in the notice, then at the later date. So that's about non-compliance with the notice for commencement date. Now, if an exemption is revoked under this clause, what's going to happen next? If the FS is satisfied that there is non-compliance, a revocation can be imposed, and how you're going to deal with the aftermath of the revocation. Right, I think we can turn to 3Y about the arrangement. Now we deal with the suspension, revocation, and expiry, and aftermath. There, yes, you may wish to deal with this later on. Please get 3X out of the way first. Right, we move on to page 0032, 3X. That's about the expiry of the NPR exemption. By the end of the permitted construction period, the exemption would expire. So if the work is completed, then that would be the end of the matter. But if it is not completed, then 3y would handle this. Now 3y applies to the following situation. A, an HER exemption is suspended or revoked. Or B, an NPR, non-permanent reclamation exemption, is suspended or revoked or expires. Bracket 2 refers to special circumstances. Despite the suspension, revocation, or expiry, the reclamation may have to continue to the extent that it is necessary to avoid safety or environmental hazards or other similar hazards that would arise if the reclamation ceases to be carried out. Bracket 3, the FS may give directions to the specified officer. A direction to reinstate the harbour affected by the reclamation. That's in connection with the non-permanent reclamation. I would like to achieve the desired effect. And B, any other directions that the FS considers appropriate. I will mention some scenarios where the remedial work will have to be undertaken. And here in 3y, the FS may be able to give directions to handle the aftermath of the situation. Page 0033, bracket 4, if the FS under subsection 3 gives direction, the compliance with which requires new harbour non-permanent reclamation to be carried out, then the new non-permanent reclamation is exempt from the presumption against reclamation, and the exemption is in force until the direction is complied with. Bracket 5, to avoid doubt. Certain provisions do not apply in relation to an NPR exemption, i.e. 3P, 3Q, 3R, 3S, 3T, 3U, 3V, 3W, and 3X. They do not apply in relation to an NPR exemption. Under subsection 4A, the legal advisor did ask the question before regarding 3M, 3N, 3O. Should they be incorporated as well? Now, we are of the view that these provisions do not apply to 4A because 4A is in relation to the work directed by the Financial Secretary. So there is no need for them to be incorporated. Please carry on. We move on to Part 5, Miscellaneous Provisions. 3Z. Absence of plan under Town Planning Ordinance doesn't prevent certain matters. Now, the fact that no draft plan, approved plan, or partly approved plan within the meaning of the TPO does not prevent any of the following from being done. A, the making of an OPNA report. B, the making of an application for an HER exemption or NPR exemption. And C, the determination under Section 3H. And bracket D, the decision in respect of an HER exemption under Section 3L, and the decision in respect of NPR exemption under Section 3O. So the idea is with the PHO, we are dealing with the earliest part of the work. When we consider rebuttal against rebuttal of presumption, there is no pre-existing plan, and that would not prevent certain works to be undertaken.
Let's move on. Excuse me. Mr. Lee Chen-kung wants to ask a question. Excuse me. You talked about there being no plans under the town planning ordinance. Which stage are you referring to exactly? And would the scale of the site matter? If everyone takes advantage of this and start works, would this situation arise in the absence of plans under the town planning ordinance, that is? Would you set a period in which a plan must be available? Chair. In response to Mr. Lee's question, this section 3 said would work this way. Say, recently we have opened the boardwalk in the East Coast Park, and this project was taken forward before there was a plan, or there was a plan that had the East Coast Boardwalk in it. So if it is not in the plan, even if it is not in the plan, it does not prevent the making of an OPNA report to show that the project has an overriding public interest need. So once we have prepared the plan and the plan has been inspected by the public and we have submitted public views along with the plan to the Executive Council for consideration, this project will then be gazetted. If I remember correctly, the boardwalk project was undertaken in accordance with Chapter 370. From what I remember, with the approval of the Chief Executive and Council, the boardwalk would then appear or would then be incorporated in the plan. So the project may not be included in a plan, but it does not prevent the making of an OPNA report to show that the project has an overriding public need. Mr. Lee, I would like to raise something. I appreciate the vision of the government. It will definitely enhance efficiency with this process. Even without circumventing the town planning ordinance, you will streamline the process. I think this is the direction we should take in future for other projects or for urban planning in general. That should help us enhance efficiency in creating land and construction. Thank you. This is just a comment, Chair. Alright? It is a comment indeed. For non-permanent reclamation, would that have to be included in a plan? I think in general it is not necessary because non-permanent reclamation would not be permanent in nature and the surface of the water would be reinstated. It does not involve the forming of land, so it should not be included in a plan. So it's just the works included in the schedule, right? Okay, please move on. Thank you. We're now at Section 3, Set A, Delegation of Powers. Section 1. The Secretary for Development may, in writing, delegate any of the powers or duties of the Secretary for Development under this ordinance to a public officer. Subsection 2 sets out some exceptions. However, the Secretary for Development may not delegate A, the power to delegate under subsection 1, or B, the power to amend Schedule 2 under Section 3, Set B. And as you may remember, Schedule 2 sets out the types of harbor enhancement works. Section 3, Set B. Amendment of Schedule 2. Subsection 1. The Secretary for Development may, by notice published in the Gazette, amend Schedule 2. Subsection 2. An amendment made under subsection 1 does not affect an HER exemption granted by the Financial Secretary under Section 3L1 before the amendment comes into operation. So this deals with what happens in the transition period. And this amendment would be made with negative vetting procedures. Please proceed. Thank you. We're now at the transitional provisions. For this bill, we want to implement some transitional arrangements. Once this bill comes into effect, this ordinance does not apply to any reclamation authorized under a relevant ordinance before the commencement of this ordinance. So this amendment ordinance, when this bill comes into effect. Right, let's move on to Clause 11, Schedule 2 added. Schedule 2 Harbor Enhancement Works: 1 Promenade and Boardwalk, 2 Cycle Track, 3 Harbor Pool, 4 Viewing Deck, 5 Ramp, that is slipways for vessels, 6 Mooring, 7 Breakwater, 8 Seawall, 9 Hangar, Crane, and Hard Stand for ship repair, 10 Wave Absorption Structure, 11 Facility for the operation of typhoon shelter or sheltered anchorage, 12 Water supplies, bunkering, or battery charging facility for supporting marine operations, 13 Device for mitigating extreme climate risks, 14 An item specified in the schedule to the Foreshore and Seabed Reclamations Ordinance, Chapter 127. Thank you, Chair. Members, any other questions in relation to this bill? We have essentially completed the clause-by-clause examination. Legal advisor, assistant legal advisor, have you identified any legal or drafting issues in the Chinese text or the English text in addition to the ones you raised before? Thank you. I have referred to the Chinese and English versions of the bill. We have not identified any other issues. We have discussed the other issues raised before, and the Legal Services Division has issued a letter. The response given by the administration to that letter has been discussed before as well. Thank you. On 28th of February this year, the Secretariat has issued a notice asking members whether they would propose amendments for the consideration of the Bills Committee. The Secretariat informed me that by the deadline of proposing amendments, no member has proposed any amendments. The administration, however, has proposed some amendments. The draft is LC paper number CB brackets 1385/2025 brackets 02. The draft amendments have been tabled. Maybe I'll take this opportunity to ask the administration to brief members on the proposed CSAs. If members wish to ask any questions, please press the request to speak button. Who is going to brief members on the proposed CSAs? Ms. Lee. Thank you. We hope to propose amendments in the paper, and we have 5 appendices. Please refer to first Appendix 1. We wanted to amend the wording to make clear what the provision says in Clause 3. So we have removed the part of the Hong Kong people to say of a natural heritage of Hong Kong, and it's the same for Clause 8. Alright, you're now going to talk about Clause 9, right? Yes. This is on Section 3C, publication of OPNA report. Apart from making available a copy at offices of the government, there should be an online version for ease of the public in their inspection. So we have made some amendments. We have now 2 parts to the subsection 1 of Section 3C. A must publish the report on the website specified by the specified officer, and B must make a copy of the report available for inspection by the public free of charge at such offices of the government as the specified officer may direct during the hours when those offices are open to the public. This is to address members' feedback to make the report available online. Subsection 2. This is a consequential amendment. Once an amended report is available, there will be similar arrangements. Subsection 2A. The specified officer must publish the amended OPNA report together with a statement containing a general description of the amendment on the website specified by the specified officer. This is already included in the original provision. It's just that we want to make sure this is available online as we did for subsection 1 as well. B must make a copy of the amended OPNA report and a statement available for inspection by the public at such offices of the government as the specified officer may direct during the hours when those offices are open to the public. Subsection 3. The OPNA report or the amended OPNA report must be made available for inspection within 21 days after the date on which the report is first made available by the specified officer for inspection. So how are we going to calculate this for hard copies? Basically, we need to say within 21 days after the date is deposited. That was the original provision, but then because we are making the report available online, we would need to say also that the address of the website specified for the purposes of subsection 1A and 2A, and BA, the addresses of the offices directed for the purposes of subsection 1B and 2B, and the hours when those offices are open to the public. As for section 3D, the amendment is in subsection 1. It is a similar amendment as that for previous provisions. After a copy of an OPNA report is first made available by a specified officer for inspection, the specified officer may at any time amend the report. These are amendments made because we are going to make the relevant documents available online. Alright, the next amendment can be found in Appendix 3. on the withdrawal of the OPNA report. Members wanted us to make clear when this would happen. So in subsection 3, we would say, instead of just publication, on the first publication in the Gazette, the powers of or rights set out in the relevant sections are no longer exercisable. Say, we may have the report published in the Gazette twice, so we want to make clear it would only be on the first, it would be on the first publication in the Gazette that the clock will start. This is a textual amendment to make clear the timing.
附錄
In Appendix 4, we have covered that earlier, and there's 3T. In exceptional circumstances, the FS can grant an extension of the permitted construction period. Now, this is moved by the government. In bracket 5, with the extension, bear with me. Bracket 5, with the extension of the permitted construction period, then the length of that period for the purposes of section 3S2B does not include the period of the extension. And 4C and 5 will be aligned. So this is only a textual amendment. The last CSA is in Appendix 5. This is in response to Mr. Lam about the incomprehensibility. That's the calculation of the suspension of the exemption. In 3V2, now we deleted continuous to run as if it had been extended, replaced by it's taken to have been extended from the end of that permitted construction period by the period of time, bracket, period of extension. So after the end of the period, we add the suspension period. So this is to put things beyond doubt and to make the text easily comprehensible. And bracket 3, we delete continues to run under subsection 2 as if it had been extended, and replaced it by it's taken to have been extended under subsection 2, and the length of that permitted period for the purposes of section 3S2B does not include the period of extension. We have explained the meaning of the extension. We try to make things more succinct. Thank you. Or any comments regarding the CSAs? The CSAs are submitted by the administration. We received them only this morning. I'd like to ask the legal advisor to see whether there are any preliminary comments or questions. Not for the time being, Chairman. As you said, Chairman, we're just presented with these CSAs only this morning. We need a bit of time to go through the Chinese and English version to ascertain whether they are in order. Right? The legal advisor, please have a look at these CSAs. Depending on circumstances, the Secretariat will, in consultation with me, decide whether we need any further meetings. If there is no need for further meetings, then the scrutiny of the bill will be deemed to be completed. The legislative timetable is as follows. Now, for the resumption of second reading debate, it is proposed to be the 14th of May 2025, Wednesday. And the date of me reporting to the House is the 25th of April, a Friday. And the deadline for notification for CSAs is 3rd of May, a Saturday. So it all depends on whether we need to have any extra meetings. So this, we give members some time to mull over the CSAs presented by the administration. And I'm sure we're all aware of the situation, and I don't think there is any follow-up, any other business. I don't have any AOB items. Any AOB items? If not, my thanks to all of you for attending the meetings. And we spend quite a bit of time scrutinizing this bill as to whether we need to have, it depends on whether we need further meetings. If not, then we proceed according to the timetable that I referred to a few moments ago. Meeting is now adjourned. Thank you all very much. Chairman, if we do not need any further meetings, I'd like to take this opportunity to thank Chairman for taking us through the bill and all the comments, invaluable comments that members made in the course of the scrutiny to improve the bill. And my thanks to the legal advisor and the secretariat. We presented the paper a little bit later. My apologies. Well, this is understandable. We all understand that. As far as I am concerned, I'm grateful to the administration for taking on board our ideas. We do understand that you need time to put together the papers, and the secretariat and the legal advisor have been rendering really great assistance, and members are really enthusiastic in taking part to scrutinize the bill. And I'm sure that everyone is pulling in the same direction in regard to this bill. And my grateful thanks to all of you here. Unless members have any further comments, the meeting is now adjourned. Thank you all very much.